We talk about the Chief Justice, Kwesi Ednene-Yeboah, who has directed trial court judges to strictly adhere to the age-long tradition of calling the cases of senior lawyers first. Justice Ednene-Yeboah explains his office has noted with concern the practice where this tradition is not being adhered to. He insists obeying such a tradition affords junior lawyers the opportunity of learning from their seniors. This is contained in a circular he issued. Let's get the full details of that. And as you can see on your screens, to all trial court judges observing age-old traditions of the bar in calling cases in court. Now, the legal profession, as we know it, is steeped in traditions and ceremonies. One of the traditions observed is the practice of calling cases of persons whose names are on the roll of lawyers in order of seniority of enrollment, notwithstanding the notion of equality at the bar. This practice, among other benefits, affords the young lawyer the opportunity of learning from seniors to whom they would not ordinarily be exposed to, thus enriching the whole legal training experience beyond what is taught in chambers and other places of work. It goes on. It has recently been drawn to my attention that some trial court judges are not observing this practice in court. While the right to call a case out of turn is not absolute and is exercisable subject to the convenience of the court, for the reasons mentioned above, I would request all trial court judges to strictly adhere to this age-old tradition and resort to inviting applications from seniors first. I hope I can count on your cooperation. And that is the statement from the Chief Justice Ednene-Yeboah. Well, let's ask some questions. What does the Ghana Bar Association make of the directive? Xavier Kuje speaks for the association. He spoke with my colleague Ernest Menu on Prime News, JoyNews Prime, last night.
The terminology seniors used in the circular does not mean that senior lawyers, as we know, 10 years and above. What it means is that if you are a lawyer and then you are 1 year at the bar and I am 2 years at the bar, my case should be called before yours. Okay. In any case, the Chief Justice does not give a directive. That is an age-old tradition and ceremony that goes with practice in Ghana.
But if that is not being adhered to, is that not, inherent? Does that not send a signal of its irrelevance in our time?
Not at all. Not at all, because every good judge will tell you that a good bench makes a good judge. What do I mean by this? You cannot just read authorities in the books. You must go and apply them. And the understanding you have upon reading might be different when you get to court. And let us all get this. To be able to even know the authorities to read, sometimes you may not know all. You listen to others in court, and when they apply it and mention it, you write it down and come back and read. But
you don't learn all of that in court. I believe that judges prepare before they go to court. They prepare their briefs. And as I know it, I may be wrong, but many junior lawyers work with senior lawyers on cases, and they must have been adequately prepared. Of course, there may be things that will come up in the news, in the courtroom, forgive me, in the courtroom, but you necessarily don't have to queue in order to learn those, do you?
Yes, I have always maintained that once you consciously elected to become a lawyer, you have elected to be a student for the rest of your life, even if possible in the next world, because the learning continues. Decided cases may not be known to you every time, unless somebody cites them. Then you also go and read, and the cases are applications of the statute laws. So you cannot just sit in your office and say that I have a good senior and that is the end, because you may not have the opportunity to meet other lawyers. The only way you meet them is when you listen to them in court. If I want to know about Richard Branson, for instance, I may not be able to meet him. But if I read whatever he writes, I know about Richard Branson.
But there will be several avenues for you to learn from some of these senior lawyers, as the Chief Justice would want juniors to learn from you. The issue is about why your case should be put on hold, necessarily because there is someone who is ahead of you, who is on the roll, who was listed on the roll before you, and not on the merit of the case that you are bringing, or even as the judge deems fit.
Ernest, what we just said, the Chief Justice has power to direct that a particular case, irrespective of the standing of the lawyer at the bar in terms of seniority, should be heard. So it is not as if that circular is saying that from now onwards, never hear any case unless a senior's case is called. It has always been the tradition, and it's been very good. Some of us have benefited from it. There is no practicing lawyer who is very good at practice that will say that what the Chief Justice has said does not add to standards. We are all complaining, or people at least have complained that standards are falling. It is all because traditions and ceremonies that are known to go with legal practice in this country are not being followed. So for me, I'm all for it. The Chief Justice hasn't done anything wrong.